You are appellant's counsel. Are you going to reserve 5 minutes for a rebuttal, sir?
Yes, please, Your Honor.
Okay, we're ready whenever you are.
Great. May it please the court, Jeffrey Michael on behalf of appellants Philip Morris USA and RJ Reynolds Tobacco Company. This is an appeal of a $26.75 million judgment in an Engel progeny case. We seek reversal on multiple grounds, several of which deal with the fraud claims, and one of which is the excessiveness of the punitive damages judgment. I'm going to start with the evidentiary error on the fraud claims, but when I first start with the decedent's name was Douglas Degnan, is how the family pronounces the name. The evidentiary error we raise is that Dr. David Burns, plaintiff's expert pulmonologist, who's also, as plaintiffs point out in their brief, an expert on public health, was allowed to testify specifically that Douglas Degnan relied on defendant's fraudulent concealment of the health risks of smoking. This testimony occurred in two different parts of the trial transcript. The first part was in direct response to a question by plaintiff's counsel: did Douglas Degnan rely on the statements of these defendants about filters and lights being safer? And
well, what's interesting about that particular testimony and that particular point is that it was very clear from this record that that was very, very much a part of the marketing efforts of Philip Morris and RJ Reynolds, that these new filters were going to somehow limit the impact, the negative impact of smoking. And it would seem to me that Dr. Burns's testimony was hard for that anyone would not have heard these statements or this advertising, because it was so pervasive, and it made sense to a lot of people. So I don't know that I necessarily read his testimony to say that he specifically relied on it. I read it to say more that in general, smokers were hearing this and believing it because it was part of the strategy.
Well, Your Honor,
break that down for me, because I know you don't agree with me, but so I want to hear your response.
Right, and I don't agree with you. I think that the smoker-specific reliance is the core of the trial of the fraud claims in these Engel progeny cases, because you've got the Engel findings that take away defense on other elements, and the cases were broken up for individual findings. So
you're looking for somebody who can give non-hearsay testimony that says that the decedent specifically said, I've heard this stuff and I believe it.
Our general legal position is yes, sir. We're looking for smoker specific. Under this court's prior Degnan decision, which is why we have not raised a directed verdict on reliance in our appeal, plaintiffs had sufficient evidence here for reliance from the fact that Mr. Degnan was exposed to the messages, switched in conformity with the messages, and there was evidence that he believed that lights and filters were safer.
And you think that previous decision was erroneously decided, so you don't agree with what you've just said. Is that right?
Right. And we preserved that Prentice is before the Florida Supreme Court. And if we lose this, you should certify conflict. But
it would seem to me that if you were right in your view of that, no one would ever be able to prove reliance.
I don't. Well, Your Honor, again, that's a preservation point. But I don't think that's correct. Well, first, we have living smoker cases. But second, we do often have circumstances where you have more than just exposure and act in conformity with exposure. You've got a specific, reason for switching to a specific brand that the spouse knows about from living with the smoker or something like that. But I want to get back to, even within Degnan, we had the right to have a trial where the jury determined whether or not Mr. Degnan relied without being told by an expert that Mr. Degnan relied. And the testimony was more specific than Your Honor I think, apprehended in your question at 3503. Dr. Burns testifies quite clearly. His verbal statements demonstrated that he relied on those messages, and his actions switching to filtered and then low tar cigarettes demonstrate by his actions that he relied on those marketing. So that's not a general statement that defendants were putting out false messages, that people in the general public were seeing those false messages, and some people fell into the bucket of believing them. Some people fell in the bucket of not believing them. Some people switched. So under the case law, why might it be proper for the expert to give that first testimony about general messages and the impact they can have, but improper to specifically say to the jury, Mr. Degnan relied? And that's because it invades the province of the jury. And these are two, I think, related but separate grounds. It also applies a legal standard that's in the jury instructions. And this court and other courts have repeatedly said where reliance from the evidence is a straightforward factual question for the jury. The jury, where there's such a question, should be free on its own to reach a conclusion. It shouldn't be told by an expert how to come out. Your Honor was the author of the Estate of Murray case, which we rely on, where a nursing home case was reversed because the expert was allowed to testify about negligence. And Your Honor wrote that it might be a matter of semantics. And it might be, I agree, it might be slicing the line thin, but you also wrote it's an important line, because you have Dr. Burns is a very experienced, esteemed expert in public health and pulmonology. And the jury tends to defer to an expert when they're answering a question on the verdict form and the expert told them specifically what to do. We've also relied on the Charles case from this court. I'm sorry, the Lewis case from this court. And that's a case where this court said you can't tell the jury as an expert that
Mr. Mitchell, I want to ask you a question about the ultimate resolution on this. And your opponent argues that if we agree with you, you still don't get a plenary retrial because of the two-issue rule, that the punitive damages could still be supported by the non-intentional torts that aren't affected by the concealment claims. What's your position on that?
So at a minimum, the punitive damages must fall or be retried once the fraud claims need to be retried. The two-issue rule does not apply to this situation because you don't have two independent causes of action or two theories of liability that necessarily lead to the same damages. So, for example, if you had a negligence and strict liability claim that both lead to the same medical expenses, then the two-issue rule can apply. Here, you've got punitive damages that were based on fraudulent conduct in part, and the jury should not have been considering that fraudulent conduct. So punitive damages based on fraudulent conduct plus negligence and strict liability is not necessarily the same amount of punitive damages as are from simply negligence and strict liability. And there's
isn't that the whole two-issue rule though with the general verdict form?
It is not, because the damages would be different. In the general verdict form, you've got two separate theories that support the same amount of damages, that support the same medical expenses or the same other type of breach of contract damages, something like that. It's not where you've got different measures of punitive damages. What we're in is a special world where the question is, is there a reasonable possibility, or can plaintiff prove that there's no reasonable possibility that the error impacted the damages? And here you had a jury awarding punitive damages for fraud when they shouldn't have been. Now, our argument does go further, and we ask for retrial of all issues in the case, as the First District has recently ordered in a couple of cases. And our reasoning there is, like the First District realized, the question of why Mr. Degnan smoked and why he continued to smoke for as long as he did and got lung cancer runs through every issue in the case. They start with class membership, which is, was he addicted, and was the addiction a legal cause of his disease? Was he addicted? Ask, why did he smoke? Goes to comparative fault. Whose fault was it that he smoked long enough to get lung cancer? And then goes to the fraud claims. Was it in reliance on defendant's fraud that he smoked and got lung cancer? And certainly punitive damages deals with the conduct that caused the harm. So that issue, we think, should result in a plenary retrial. But at a bare minimum, the fraud claim gets reversed and the punitive damages fall. The fraud claim being reversed would also result in application of comparative fault, which would reduce the compensatory damages and further call into the question the punitive damages, because then you've got a reduction in compensatory damages, which changes certainly the ratio. And the jury was aware of the fact that because they found on fraud for the plaintiff, the compensatory damages were not going to be reversed. I did, on the, going back to Dr. Burns's testimony, I wanted to just reprise the second occasion where that first occasion was directly in response to a question of, did Mr. Degnan rely? The second line of testimony, Dr. Burns testified at greater length, and it was in response to the question of why the fraudulent statements mattered to Mr. Degnan. And he gave 3 reasons, all of which led to the conclusion that what Mr. Degnan said and what he did demonstrate that he relied on defendant's fraud. That is, I think, the line from that we have quoted from the Lewis case is that the police officer doesn't have special knowledge of the intent of a defendant, can't get inside the defendant's mind. Similarly here, Dr. Burns had no specialized knowledge or expert knowledge of the inner workings of Mr. Degnan's mind. It's like any other fraudulent misrepresentation case. Would think of a fraudulent misrepresentation contract case or something. Would you call in an expert witness to look at everything the plaintiff did and say, well, you know, certainly in that case, I've reviewed the depositions, I've reviewed the contract, and yes, the plaintiff relied that there would be a certain number of parking spaces at the building? No, you wouldn't, because that's up to the jury whether or not the defendant the defendant's misrepresentations have been relied upon. The other error that we raise with respect to the fraud claims, other than our preservation point that Degnan is conflicts with Prentice, is that even if he relied, so we're taking it as a given that he relied, was that reliance a legal cause of injury? Was it a but-for cause of injury? So that requires looking at what would have happened had he not relied. When would he have stopped smoking? And would he have stopped smoking soon enough to avoid his lung cancer? And we know from Dr. Burns that that date is 1977. That if he had quit by then, Dr. Burns's testimony is that would make it more likely than not that any smoker who quits 15 years ahead of time, wouldn't develop lung cancer at the time which they did. So the question is, but for his reliance, would Mr. Degnan have quit by 1977? And there is simply insufficient evidence in the record for a reasonable jury to reach that conclusion. And our
Sir, just so you know, you're at your 15-minute mark. It's your time. Use it any way you want to.
Thank you, Your Honor. Then I do need to touch on the excessiveness of the punitive damages for a minute. Make no doubt about it. If this court were to affirm the punitive damages award, it will be affirming the highest ratio of punitive to compensatory damages that has ever been affirmed in an.
Well, it depends upon how you do the math, right?
Yes, and that is, I agree, a linchpin of our argument. And we've got the Caravan case and the Gravinsky case that we rely on that says you can't have essentially a calculation that's based on an impossibility. That here, you're not going to have both defendants pay the entirety of the compensatory damages. They're going to get split up. So you either attribute the compensatory damages among us for the ratio calculations, or you can group us together because punitives were the same.
Well, the question is, were they joint and severally liable? Because we can't jump to the conclusion that these two big rich companies are going to divide it evenly. They probably will, but there's no way we can know that. So if they're jointly and severally liable, that's really what we have to look at the whole number, not half the number.
Well, if you're doing that, then you should look at the whole number of punitive damages, like the pre-99 statute.
Well, except for they were each specifically awarded the punitives, not joint and severally.
Right, but the pre-99 statute says you calculate, for example, the cap based on the total punitive damages awarded to the claimant, and here the claimant's the estate, and you compare that to the compensatory damages. You don't do a one-by-one analysis. And again, as the Gravinsky case says, otherwise you're calculating based on an impossibility. Say you had 100 defendants jointly and severally liable. Are you able to get a collective ratio that's in the thousands? That can't possibly be the case.
Let me ask you a question, because you're going to run out of time, and I
And
want
he's so close to being out of time, it's ridiculous. You ought to let him save what he's got left.
I'll give it to you so you're ready on rebuttal. Talk to us about your opponent's suggestion that if we do find error in the punitive damages, we should remand for entry of an award for 3 times the compensatories. And I'll take the answer on rebuttal, but I do want to hear what you have to say about that.
Okay. So if you're through, you have 2 minutes left. If you're going to answer now, that's up to you.
I'll reserve and take the time to think about it.
Okay. You have 2 when we come back. Mr. Sales?
Thank you, Your Honor. Good morning. Is it still morning? Almost not yet, but good morning, everyone. David Sales, and may it please the court. I'm for the appellee, of course. What I'd like to do, if I may, is discuss the issues that have been raised by the court in the following order. Judge LaBritte's discussion about what happens if there is a reversal on any aspect of the fraud claims, then Judge Morris's questions about the sufficiency of the evidence, and then, if I have time, these other additional issues. And the reason for that is counsel has conceded, I think, the words he used were slim slicing with respect to the testimony of Dr. Burns, and to mix metaphors, and I'll talk about it more in a moment. But in the case of slim slicing on an abuse of discretion standard, the tie ought to go to the runner, who is the trial judge. But I want to talk, because I do think you're, from a point of view of judicial administration, in this case, knowing, as we all know, that Prentice is before the Supreme Court, if they adhere to their internal guidelines, there probably will be a disposition of that case fairly soon. And as your honors know, it's up on appeal on a conflict between Degnan 1. But I do want to tell the court, give the court a little bit of a perspective about where we are and why we believe that the remedy, we don't think they come close to showing error on the fraud claims. But if your honors conclude that there is, either because of the Burns issue or the sufficiency of the evidence, we're way past this court's standards on that with Evers 1, which 2 members of the panel were on in terms of the sufficiency of the evidence. But Here's my perspective on it, just so the court knows. I was here 5 years ago defending the first judgment in its case. It went back for two reasons, both of which were errors that were committed by the trial court as a result. With no disrespect to Judge Day, he's an excellent judge. I say one of the best I've seen in 30 plus years of trial practice. But two errors, one that's not important in this case, and one relating to the jury instructions on the concealment claims. And we went back and we were very careful when we tried the case to comply with this court's guidance. There is risk, we know that the Supreme Court is going to hold that in a concealment case, what matters is what the defendant said as opposed to what they hid. If that's the law that we have to deal with, that's going to be the law that we have to deal with. And the consequences aren't clear in this case because despite what my friend has told your honors, there was direct evidence of reliance on that. But I want to give the court, again, from the perspective of judicial administration, what my perspective is. I was here 5 years ago. We did what the court told us to do. Before that happened, our widow died. And before that happened, there was another aborted trial when we failed to get a jury. So if you send us back on these fraud claims, we are going to be trying this case for amount to a third and a fraction time. They haven't raised anything that should lead to that result, but I am authorized and I want to inform the court that if for any reason you should reverse, and we don't think you should, for any reason, including Prentice or this Burns issue on these fraud claims, that we are not going to retry. If your honors accept our argument, and this is where I would like to spend the bulk of my time today, if the court permits it, we are not going to retry these fraud claims. And you should affirm this judgment, even if they're defective for any reason, and direct the court to enter judgment, except for reducing the comparative fault. But everything else should be the same. And I want to tell the court why. I argued the Whitmire case in the first DCA. It was argued the day before the Prentice case to the same panel. One of the judges went on the federal bench, and it took a long time for them to come out with Whitmire, but it was the same panel except for one change. And in that case, the first district, it did make new law. It held for that district that there have to be statements. And what did it do? It remanded the case for entry of a judgment, except for reducing the comparative fault, reducing the compensatory damages by comparative fault. That's what should happen here. Why they did different in Prentice, which was argued the next day when the issue was, it was jury instructions versus the law and concealment for directed verdict purposes, but it makes no sense to me. And I've struggled with that. And I'm obviously a student of this litigation. But my clients don't want to retry this case for any reason. And here's why, most respectfully, even if you find error, or even if Prentice interferes with our ability to prove the cases the way we did because your honors colleagues told us to, including Judge Kelly, most respectfully, we did what your honors told us to do. And so we are asking the court, even if Prentice does not go our way, there's been a change in composition of the court. I'm not saying that matters, but it might. Here's what I have to say about it. The interrogatory verdict in this case was discrete questions. Question one, was Mr. Degnan addicted to nicotine, and was his addiction a legal cause? By the way, Dr. Burns testified on both of those issues without objection because it's a species of proximate cause, which is a fact similar to reliance. And the issue of whether Mr. Degnan relied on lies or what was concealed to him has nothing to do with whether he was biologically addicted to nicotine, zero, and whether his addiction was a legal cause. There's no reason for us to retry that issue under any circumstance if the fraud claims are defective. Comparative fault. Mr. Michael touched on this. I want your honors most respectfully to look at pages 1270 to 71 of the Engel decision. What it says in rejecting a Seventh Amendment claim by the same defendants, that you have to be able to look at what the defendants did and what the plaintiff did in order to resolve a comparative fault. The court expressly held that no, in this litigation, the jury is presumed, the jury, once class membership is established, the jury is told that there was negligence and product defect without ever knowing what the reasons for the Engel jury's findings in that regard was. If we go back and try the issue of comparative fault for the reason that Mr. Michael gave, there has to be a comparison of one against the other. The jury's not going to make that comparison, and there's no reason to retry it. But most importantly, and Mr. Michael did acknowledge this, This jury was told, I think it was a total of 3 times in the jury instructions, and obviously by the parties who argued the case, that comparative fault and intentional torts were different. They were told twice in the instructions that if there was a finding on fraud, there was comparative fault wouldn't apply. They were told on the verdict form in italicized language not to reduce because of comparative fault, because there would be no reduction if we won on fraud. They knew that. But most importantly, which I acknowledge I omitted from our brief and I apologize, in this case, we admitted comparative fault and the jury was told that at page, I think it's 41, 48 of the transcript. And all they were doing with comparative fault, consistent with 1270 to 71 of the Engel decision, was measuring the extent of the causal connection between what Mr. Degnan did to himself, if you think about it the way the defendants conceptualize it, and the total harm. The other points are compensatory damages. I don't understand the 4th District's decision in Gentile. It's a non-Engel case where Judge DeMorgian wrote for the court that the compensatory damages in a wrongful death claim could be different if it's fraud versus negligence or product defect. I don't understand that. It's 768.21. It supplies the measure of damages. It's what we argued. And the survivors in this case had intangible losses that are specified by statute, and they don't change because Mr. Degnan did or did not believe what the defendants were lying about. That takes us to the question of punitive damages, and this is what Your Honor, Judge LaBritte focused on. This was there's no mistake about it. This is a general verdict on entitlement to punitive damages. And Mr. Michael has told the court in his brief and today, without any authority, that the jury was awarding fraud damages, punitive damages, only based on the fraud. That flies in the face of the Supreme Court's decision in Soffer, S-O-F-F-E-R, which the parties cite, I do believe, which says that we could recover punitive damages for the non-intentional torts. And they had an opportunity. They knew Prentice was up on appeal. They knew they were going to challenge Dr. Burns's testimony because they did so in post-trial motions. They had an opportunity to ask the court for the jury to decide the issues of entitlement separately, and they didn't do it. So we don't think that we should have to try that issue again. And I just want to give the court a couple of examples. Soffer says, plaintiffs, you can't rely on the Engel findings for your punitive damages. And I didn't object to it. They put an instruction that the court read that said they had to consider independent evidence, independent of the Engel findings, in deciding whether punitive damages were to be awarded. In addition to that, at my colleague's request, Mr. Michael and his colleague from Reynolds, the jury was told, I forget the page number, I'll look it up if it's necessary, in the phase 1 instructions, that it could only award punitive damages based on the specific conduct that harmed Mr. Degnan, that caused his lung cancer and killed him. Now, we don't know, because there was no separate verdict on entitlement, what they found. And that was on them. And what the 2-issue rule says is that if there is a general verdict on questions like that, that they have lost the right to say, as Mr. Michael is arguing to this court, well, it was all based on fraud. 2 examples, and then I'll move on to the next issue. One is, this jury could have found, because we proved, and it was unrebutted, that they tried to manipulate the cigarettes that Mr. Degnan smoked by altering the effectiveness of nicotine. That is, in some minds, outrageous, and they could have found that they should be punished for that. That had no bearing on what they were lying about, but they certainly could have independently found that punitive damages were warranted according to the standard that was described by the court for any of those independent reasons, 4 bullet points under the old instructions, because they were lying about things or hiding what they knew. And they say in their reply brief that punitive damages are based on a single course of conduct, but they cite the post-99 statute. I am sure the court is probably aware, I lost a few days ago in the Supreme Court of Florida the question of whether or not the post-99 statute applies, yes or no, to post-99 deaths. Your Honor, Judge Morris, I believe you had agreed with the other districts that had said that wasn't the case, and I lost that, even though it was split 3-1. This is a pre-1999 death, and that course of conduct language does not appear in the earlier statute. That is not in dispute. And so when Mr. Michael says the punitive damages were awarded only for a course of conduct and only related to the fraud, he's just wrong about that. We had an independent right to prove, and we did, entitlement to punitive damages on the independent grounds. And we don't know why the jury found that we were entitled, and that is a problem for them. So for those reasons, your honors ought to affirm on all issues, even if you find that there's a problem with the fraud claims for reasons relating to Dr. Burns or because Prentice changes. And I think you probably have an opportunity to consider that fairly soon. I do want to say, if Prentice comes out before the court disposes of this case, it is possible that it would be useful for the court to hear or have at least additional briefing, because it's the biggest thing going on in Engle litigation. And I asked the court to consider if Prentice is decided adversely to either party about how that might affect the issues that are before the court here. On the Burns issue, here's my request. I request that the court read pages 3385 to 3400 of the transcript, 3496 to 3503, 3587 to 3613. Because what you will find and why you will understand that it was important and useful for the jury to hear from Dr. Burns is that he was explaining the importance in the context and the environment that Mr. Degnan lived in. And just a little point about that. Cigarette advertising is not what it once was. It went off the air in 1971, and it's completely or virtually eliminated except for certain contexts now because of different litigation. In 1971, we have more boomers alive today, more post-boomers alive today than we have boomers. And most jurors have never heard cigarette advertising on television. And Dr. Burns has studied this for his lifetime about the effect and the impact of the kind of messaging that was prevalent then on people like Mr. Degnan. And all he was doing was talking about the consequences of that type of messaging on people who smoke. And specifically, they say in their reply brief, he wasn't talking about design changes in cigarettes. He absolutely was. And if you read those portions of the record, you will see it. He was 100% talking about how when you say your cigarette is filtered, even though you know it's an illusion, what that does to people. He used demonstrative aids, which I think are 30372 and 30373 of the record, which show a cycle of addiction and how those kinds of products, filters and lights, intercept people who are trying to quit. And the evidence was that Mr. Degnan tried to quit smoking many, many, many times. And that's why it's important and useful to have an expert. But just think about it most respectfully, if you would, for a moment. In their initial brief, they said, look, this applied a legal standard to a set of facts. And we responded to that. They cited cases like Murray. Reliance is not a legal standard. And then they came in their reply brief and they said, well, you can't testify about facts either if you're an expert. Well, that's plainly not true. Yes, a police detective can't say so-and-so is guilty. And yes, so-and-so, a police detective can't say, I see the videotape and the defendant is the one using the credit card, especially when he's previously stated he can't tell. They can't do that. So there are certain contexts, and it's important to remember this is an abuse of discretion issue. And that's why, as I say, the tie, it was at least reasonable. They point out, Judge Ransberger heard these arguments for 30 pages. If you added them all up, it's more than that. And now they're coming in and saying that he didn't give us adequate consideration, or I don't know. They certainly suggest that with respect to the post-trial motions. So in this setting, where there is someone who is helpful in explaining to a jury why these things affect, which was unobjected to, addicted smokers, and without objection, Dr. Burns was able to review. You pointed out, Judge Morris, how do you do this when somebody's deceased? And what inevitably happens is there may be some hearsay objections, and then everybody realizes, well, you can't do the case. You can't cross-examine somebody like Dr. Burns unless you point out the helpful parts of the fact witness's testimony. So it all came out in direct, cross, redirect. All of the witness testimony, all of the things that the people said through Dr. Burns, repeating what they had said that the jury had already heard. And that sort of gets us to the harmless error point. It couldn't be harmful error because the jury heard the same thing over and over again. And the one-time use of the word rely by an expert who can talk about facts. If it were true they couldn't answer a question, speak to something on a verdict form, he couldn't say, as he did without objection, addiction, yes. Causation on addiction, yes. Facts. And as I said, reliance is a species of proximate cause. The next issue was the sufficiency of the evidence, and I just very briefly touch on that. Two of your honors were on Evers. We've had the Holgren case as a case of mine. We have case after case after case that talks about the sufficiency of the evidence. Even if, and I'll get to it in a moment, it's true that Dr. Burns said, which he didn't, that he had to quit by 77 to avoid lung cancer. The evidence in this case supports a verdict for the plaintiff on the fraud claims because we put on the same evidence that your honors have discussed and your honors colleagues have discussed many, many times, which would allow us to reach the jury. But under the totality of the evidence and in the light most favorable to us, even if 77 is material, and I submit it's not, Mr. Dagnan was, like the experts testified, he was the perfect customer for them. He did exactly what they wanted to over time, and the jury could have certainly reasonably found, as we argue, that earlier action would have been maintained by him as well. But on this 77 issue, you know, we confront this in every case, and if you look at the questions and answers, you may find them somewhat peculiar, the way the questions and the answers talk about declining risk and talking about getting cancer when he did, which is in the question and it's in the answer. And the reason for that is because that's what declining risk is about. It is a question of when it is probably more likely or not that someone will get cancer. It's not a statement about the probability of getting cancer at a later time. And the citation to Gooding and the concept of expert testimony in a malpractice case doesn't have anything to do with that. But most importantly, this jury heard plenty of information, similar and I think better, at least based on the way your honors described it in Evers, that would have supported the verdict. You know, there's no clock, Judge. I'm sorry. How much time do I have?
You got about a minute.
Judge LaBritt, in response to your question about the 3 times limitation, you know, we don't want that. We know that the Supreme Court precedent, and I have been personally, if I can use the word burned by this before, if you direct the trial court to remand and reduce the punitive damages or any damage or anything else, they're entitled to a new trial, which we're arguing strongly against. So that's the law. The name of the case is Waste Management, and I forget the other party. The parties haven't cited it because it's not really an issue in this case. But we don't want that, Your Honor, and we would ask the court not to do that. And then finally, if I can just briefly on the ratio, I look at it this way. Evers, 2 million over 12 million. 2 of your honors were on that panel. This is 2 million plus, 2 million plus over 12 million plus, 2 million plus over 12 million plus. The defendants have been punished by amounts that way exceed this. And they sort of throw cold water on the idea that, well, you don't look at what happened to Mr. Dagnan, but the courts are very clear on that. And their idea that there's you can look at what happened because the Supreme Court on the due process angle has said the harm and potential harm, all of it is important. And there
Mr.
is
Sales, you're out of time.
Thank
Matter of
you.
fact, you're over time. But you look like you're winding up to go 5 more minutes.
No, I'm good. There is no mechanistic application of the ratio. For the reasons that we've given, we ask that the court affirm with the caveat that we discussed in response to Judge LaBritt's questions. Thank you very much.
Thank you. Mr. Michael, you have 2 minutes.
Thank you, Your Honor. I'll start with the 3-to-1 question, which I understand from plaintiff's brief to be directed at due process remitter, which in that context, we don't have an option for a new trial. But we think 3-to-1 is something that should be up to the trial court. We think you should remand for the trial court to come up with a new ratio. And, you know, we'll see what the judge does at that point. In terms of the 2-issue rule, I am not arguing, and I have never argued, that the jury here only based punitives on fraud. What I'm saying is that their punitive determination could have been different if they were not considering fraudulent conduct. And Mr. Sales filed the Spearman case the other day as supplemental authority from the third district on the two-issue rule. And I would direct you especially to the concurrence by Judge Loeb that says the two-issue rule does not apply where the damages could have been different on the two different claims. And certainly punitive damages for negligence and strict liability can be different than punitive damages for fraudulent conduct or both of them combined, which is what occurred here. So I would respectfully request that, and I agree we can have supplemental briefing depending on Prentice, but if the fraud claims are getting reversed, at a minimum, the punitives fall. But in general, appellants would urge the court to reverse. Thank you.
Okay. You both did an outstanding job on this case, and we thank you very much for your efforts. Okay. Have a
Thank you,
good
Your
day.
Honor.